NITI Ayog. Establishment of the NITI Ayog. On 1st January 2015, NITI Ayog was established. It replaced the Planning Commission. Like Planning Commission, NITI Ayog is also created by an executive resolution of the Government of India. It is a non-constitutional or extra-constitutional body. NITI Ayog is the premier policy think tank of Government of India, providing both directional and policy inputs. While designing strategic and long-term policies and programs, NITI Ayog also provides relevant technical advice to center and state. Center to state one-way flow of policy that was hallmark of the Planning Commission era. Now it is replaced by a genuine and continuing partnership of states. NITI Ayog uses bottom-up approach instead of top-down model which was used by the Planning Commission. Hubs of the NITI Ayog. First, Team India Hub. Second, Knowledge and Innovation Hub. Composition of NITI Ayog. Prime Minister is the chairperson of the NITI Ayog. Governing Council consists of Chief Ministers of all states and Lieutenant Governors of Union Territories in India. Regional councils will be created with the fixed term to address particular issues and possibilities affecting more than one state. It is summoned by the Prime Minister and consists of Chief Ministers of states and Lieutenant Governors of Union Territories. These will be chaired by the chairperson of NITI Ayog or his nominee. Special invitee. Eminent experts, specialists with relevant domain knowledge which will be nominated by the Prime Minister. The full-time organizational framework include, in addition to Prime Minister as a chairperson, Vice Chairperson appointed by the Prime Minister, members, full-time members. Second, part-time members. Part-time members includes maximum of 2 members from foremost universities, leading research organizations and other innovative organizations in an ex officio capacity. The ex officio members, maximum of 4 members include Council of Ministers nominated by Prime Ministers. Chief Executive Officer appointed by the Prime Minister for fixed tenure. He will be in the rank of Secretary to Government of India. Specialized wings of NITI Ayog. First, Research Wing. It develops in-house sectoral expertise. Second, Consultancy Wing. It provides a marketplace of weighted panels of expertise and funding. Third, Team India Wing. It comprises of the representatives from every state and ministry and serve as a permanent platform for national collaboration. Each representative ensures that every state ministry has continuous voice and stake in the NITI Ayog. B. Establishes a direct communication channel between state, ministry and NITI Ayog. Objectives of the NITI Ayog. To evolve a shared vision of national development priorities, sectors and strategies with the active involvement of states. To foster cooperative federalism. To develop mechanisms to formulate credible plans at village levels and aggregate this progressively at higher levels of government. To ensure on areas that are referred to it that the interests of national security are incorporated in economic strategy and policy. To pay special attention to non-benefiting sections of our society. To design strategic and long-term program frameworks and initiatives and monitor their progress and their efficacy. To create a knowledge, innovation and entrepreneurial support system. To monitor and evaluate the implementation of programs and initiatives. To focus in technology upgradation and capacity building. Functions of the NITI Ayog. First, design policy and program framework. Second, foster cooperative federalism. Third, monitoring and evaluation. Fourth, think tank and knowledge and innovation hub. NITI Ayog's 7 pillars of effective governance. First, pro-people. Second, proactive. Third, participation. Fourth, empowering. Fifth, inclusion of all. Sixth, equality. Seventh, transparency. Cooperative federalism. NITI Ayog emphasizes cooperative federalism and good governance. 2 key features or aspects of cooperative federalism are: first, joint focus on national development agenda by the center and state. Second, advocacy of the state perspectives with central ministries. The various manifestations of cooperative federalism are: first, meetings of governing council; second, subgroups of chief ministers on different subjects; third, task forces on specific subjects; fourth, NITI Forum for Northeast; fifth, sustainable development in the Indian Himalayan region; sixth, development support services to states; seventh, sustainable action for transforming human capital; 7. National Human Rights Commission. Establishment of the Commission. It is a statutory body established in 1993 under Protection of Human Rights Act 1993. This act was amended in 2006. Objectives of the establishment of the Commission: A. To strengthen the institutional arrangement; B. To look into allegations; C. To implement and strengthen efforts that have already been made. Composition of the Commission. The Commission consists of Chairman and 4 other members. Chairman should be retired Chief Justice of India. Other members should be serving or retired judges of Supreme Court, a serving or retired Chief Justice of High Court, 2 persons having knowledge or practical experience with respect to human rights. They hold office for 5 years or up to the age of 70 years. They are not eligible for further employment. Chairman and members appointed by President on the recommendations of 6-member committee. The committee consists of Prime Minister, Speaker of Lok Sabha, Deputy Chairman of Rajya Sabha, Leader of Opposition in both houses of Parliament, and Central Home Minister. Apart from this, the Commission also has 4 ex officio members. First, Chairman of National Commission for Minorities, National Commission for STs, National Commission for SCs, National Commission for Women. President can remove Chairman or any other member under following circumstances: first, insolvent; second, paid employment; third, unfit to continue due to infirmity of mind or body; fourth, unsound mind; fifth, convicted and sentenced to imprisonment. President can also remove the chairman or any member on ground of misbehavior or incapacity. However, these cases are referred to Supreme Court for an inquiry. Salary, allowances, and other conditions of service determined by the central government. Functions of the Commission: A. To investigate into violation of human rights or negligence in the prevention of such violation. B. Intervene any proceeding involving allegation of violation of human rights pending before court. C. To visit jails and detention places to study living conditions and make recommendations. D. To review the constitutional and other legal safeguards and recommend measures. E. To review the factors including act of terrorism. F. To study treaties and other international instruments on human rights and make recommendations. G. To undertake and promote research in field of human rights. H. To spread human rights literacy and awareness. I. To encourage efforts of NGOs working in the field of human rights. J. To undertake other functions necessary for promotion of human rights. Role of the Commission. Functions of the Commission mainly recommendatory in nature. It has no power to punish violators of human rights, nor to award any relief including monetary relief to victims. Recommendations are not binding, but it should be informed about the action taken on its recommendations within 1 month. Moreover, the Commission has limited role, powers, and jurisdiction with respect to violation of human rights by members of the armed forces. In this way, central government should inform Commission of the actions taken on the recommendations within 3 months. The Commission submits its annual and special reports to central government and state government concerned. Working of the Commission. The headquarters of the Commission is located at Delhi. It has all powers of a civil court and its proceedings have a judicial character. The Commission has its own nucleus of investigating staff. Besides, it is empowered to utilize services of any officer or investigation agency. It is not empowered to inquire into any matter after expiry of 1 year. The Commission may take any of the following steps during inquiry. First, may recommend to make payment of compensation or damages to victim. Second, may recommend initiation of proceedings for prosecution or any other action against the guilty of public servant. Third, may recommend for grant of immediate interim relief to victim. Fourth, may approach the Supreme Court or High Court for necessary directions, orders, or writs. State Human Rights Commission. National Human Rights Commission and State Human Rights Commission were created under Protection of Human Rights Act 1993. Accordingly, 26 states have constituted State Human Rights Commission. A State Human Rights Commission can inquire into violation of human rights only with respect to subject mentioned in the state list and concurrent list of the 7th schedule of the Constitution. However, if any case is already being inquired by National Human Rights Commission or any other statutory commission, then State Human Rights Commission does not inquire into that case. The Commission submits its annual report or special reports to the state government. Human Rights Courts. The Protection of Human Rights Act 1993 also provides establishment of human rights court in every district for speedy trial. These courts can be set up by state government only with the concurrence of Chief Justice of High Court. Composition of the Commission. State Human Rights Commission consists of chairman and 2 other members. The chairman should be a retired Chief Justice of High Court and members should be a serving or retired judge of High Court or a district judge with minimum 7 years experience as district judge and a person having knowledge or practical experience with respect to human rights. Chairman and members are appointed by the governor on the recommendation of a committee. The committee consists of Chief Minister as its head, Speaker of Legislative Assembly, State Home Minister, and Leader of Opposition in Legislative Assembly. If state has Legislative Council, then the Chairman of the Council and Leader of Opposition in the Council also will be member of the committee. Further, a sitting judge of High Court or District Court can be appointed only after consultation with the Chief Justice of High Court. Chairman or members hold office for 5 years or until age of 70 years. They are not eligible for further employment. They can be removed only by the President. President can remove chairman or any other member under following circumstances. First, insolvent. Second, paid employment. Third, unfit to continue due to infirmity of mind or body. Fourth, unsound mind. Fifth, convicted and sentenced to imprisonment. Salaries, allowances, and other conditions of service are determined by the state government. Central Information Commission, established in 2005 under provisions of Right to Information Act 2005. It is a high-powered independent body. Composition of the Commission. It consists of Chief Information Commissioner and not more than 10 Information Commissioners. They are appointed by the President on the recommendation of a committee. And the committee consists of Prime Minister as a chairman, Leader of Opposition in Lok Sabha, a Union Cabinet Minister nominated by Prime Minister. They should be persons of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism, mass media, or administration and governance. They should not be member of parliament or member of legislature of any state or union territory. They should not hold office of profit or connected with any political party or carrying on any business or pursuing any profession. Chief Information Commissioner and Information Commissioner shall hold office for such firm as prescribed by central government or until age of 65 years. They are not eligible for reappointment. President can remove them under following circumstances. A. Insolvent. B. Convicted of an offence of moral turpitude. C. Paid employment. D. Unfit to continue due to infirmity of mind or body. E. If he has acquired financial or other interest as is likely to affect his official functions. President can remove them on grounds of misbehavior or incapacity. Such matter inquired by Supreme Court. Their salary, allowances, and other service conditions prescribed by central government. Powers and functions of the Commission. First, it is duty of the Commission to receive and inquire into a complaint from any person. Second, order inquiry into any matter if there are reasonable grounds. Third, Commission has powers of civil court. Fourth, examine any public record which is under public authority. Fifth, Commission has power to secure compliance of its decisions from any public authority. Sixth, Commission submits its annual report to central government. Seventh, Commission recommends steps to promote conformity of Right to Information Act. State Information Commission. Right to Information Act 2005 provides establishment of Central and State Information Commission. Composition of the Commission. It consists of State Chief Information Commissioner and not more than 10 Information Commissioners. They are appointed by the Governor on the recommendation of a committee. The committee consists of Chief Minister as a chairman, Leader of Opposition in Legislative Assembly, a State Cabinet Minister nominated by CM. They should be persons of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism, mass media, or administration and governance. They should not be member of parliament or member of legislature of any state or union territory. They should not hold office of profit or connected with any political party or carrying on any business or pursuing any profession. State Chief Information Commissioner and Information Commissioners shall hold office as prescribed by central government or until age of 65 years. They are not eligible for reappointment. Governor can remove them under following circumstances: A. Insolvent. B. Convicted of an offence of moral turpitude. C. Paid employment. D. Unfit to continue due to infirmity of mind or body. E. If he has acquired financial or other interests as likely to affect his official functions. Governor also can remove them on the grounds of misbehavior or incapacity. Such matter inquired by Supreme Court. Their salary, allowances and other service conditions are prescribed by central government. Powers and functions of the Commission. First, it is duty of the Commission to receive and inquire into a complaint from any person. Second, order inquiry into any matter if there are reasonable grounds. Third, Commission has powers of civil code. Fourth, examine any public record which is under public authority. Fifth, Commission has power to secure compliance of its decisions from any public authority. Sixth, Commission submits an annual report to state government. Seventh, Commission recommends steps to promote conformity of Right to Information Act. Central Vigilance Commission. The establishment of the Commission. It is the main agency for preventing corruption in central government. Established in 1964 by an executive resolution of central government. The establishment was recommended by Santanam Committee on Prevention of Corruption. In 2003, Parliament gave a statutory status to the Commission. In 2004, Government of India authorized Central Vigilance Commission as designated agency to receive complaints of corruption or misuse of office from whistleblowers under the Public Interest Disclosure and Protection of Informers Resolution, which is popularly known as Whistleblowers Resolution. Composition of the Commission. The Commission consists of Central Vigilance Commissioner and not more than 2 Vigilance Commissioners. They are appointed by the President on the recommendation of a 3-member committee. The committee consists of Prime Minister, Union Home Minister and Leader of Opposition in Lok Sabha. They hold office for 4 years or until age of 65 years. After tenure, they are not eligible for further employment in central or state government. President can remove them under following circumstances: A. Insolvent. B. Convicted of an offence of moral turpitude. C. Paid employment. D. Unfit to continue due to infirmity of mind or body. E. If he has acquired financial or other interests as is likely to affect his official functions. They also can be removed on the grounds of misbehavior or incapacity. However, such matter inquired by Supreme Court. The salary, allowances and other service conditions are similar to UPSC. Organization of the Commission. The Central Vigilance Commission has its own secretariat. It consists of secretary, joint secretaries, deputy secretaries, under secretaries and other staff. Chief Technical Examiners Wing, Wing of Commissioners for Departmental Inquiries. Functions of the Commission. First, to inquire and investigate on reference of central government. Second, to exercise superintendence over functioning of Delhi Special Police Establishment. Third, to give directions to Delhi Special Police Establishment. Fourth, to review progress of investigations conducted by Delhi Special Police Establishment. Fifth, To review the progress of pending applications. 6. To tender advice to central government and its authorities. 7. To exercise superintendence over vigilance administration. 8. To inquire complaints received under public interest disclosure and protection of informers' resolution and recommend appropriate action. 9th. Central government is required to consult Central Vigilance Commission in making rules and regulations governing vigilance and governing matters. 10th. The Central Vigilance Commissioner is also chairperson of 2 committees on whose recommendations central government appoints Director of Delhi Special Police Establishment and Director of Enforcement. Working of the Commission. Central Vigilance Commission conducts its proceedings at its headquarters, New Delhi. It has powers of civil court. The Central Vigilance Commission presents annually to the President. Jurisdiction of the Commission. The jurisdiction of the Commission extends to first, members of all India services, second, scale 5 rank officers and above in public sector banks, 3. Grade D officers and above in RBI, NABARD and SIDBI, 4th, managers and above in general insurance companies, 5th, senior divisional managers and above in life insurance corporation. Whistleblowers Protection Act 2014. It provides mechanism to investigate corruption and misuse of power by public servant and protect anyone who exposes wrongdoing in government bodies, projects and offices. The Act also ensures punishment for false or frivolous complaints. The Act provides adequate safeguards. It allows to make a public interest disclosure before a competent authority. The law does not allow any anonymous complaints. The maximum time period for making a complaint is 7 years. Exemptions. The Act is not applicable to Special Protection Group personnel and officers constituted under Special Protection Group Act 1988. Central Bureau of Investigation. Central Bureau of Investigation was set up in 1963 by a resolution of the Ministry of Home Affairs. Later, it was transferred to the Ministry of Personnel. The Special Police Establishment set up in 1941 was also merged with the CBI. The establishment of the CBI was recommended by Santanam Committee on Prevention of Corruption. The CBI is not a statutory body. It derives its powers from the Delhi Special Police Establishment Act 1946. The CBI is the main investigation agency of the central government. It also provides assistance to the Central Vigilance Commission and Lokpal. It is the premier investigation agency of India. It operates under the jurisdiction of the Ministry of Personnel, Public Grievances and Pensions. The CBI is exempted from the provisions of the Right to Information Act. The CBI is the India's officially designated single point of contact for liaison with the Interpol. Organization of the CBI. The CBI has following divisions. First, Anti-Corruption Division. Second, Economic Offences Division. Third, Special Crimes Division. Fourth, Policy and International Police Cooperation Division. Fifth, Administration Division. Sixth, Directorate of Prosecution. Seventh, Central Forensic Science Laboratory. Composition of the CBI. The CBI is headed by a director. The director of the CBI, as Inspector General of Police, Delhi Special Police Establishment, is responsible for the administration of the organization. The director of CBI enjoys security of 2-year tenure in office by the Central Vigilance Commission Act 2003. The Lokpal and Lokyuktas Act 2013 amended Delhi Special Police Establishment Act 1946 and made following recommendations with respect to composition of CBI. The central government shall appoint the director of CBI on the recommendation of a 3-member committee. And the committee consists of Prime Minister, Leader of Opposition in Lok Sabha, Chief Justice of India, or the Judge of Supreme Court nominated by him. Later, Delhi Special Police Establishment Act 2014 made a change in the composition of the committee. It stated that where there is no recognized leader of opposition in the Lok Sabha, then the leader of single largest party in the Lok Sabha would be a member of that committee. Functions of the CBI. First, investigate cases of corruption, bribery, misconduct of central government employees. Second, investigate infringement of fiscal and economic laws. Third, investigate serious crimes having national and international ramifications. Fourth, coordinate the activities of anti-corruption agencies and various state police forces. Fifth, maintain crime statistics and disseminating criminal information. Investigate conventional crimes like murder, kidnapping, rape, etc. on the reference from state government or when directed by the Supreme Court or High Courts. The CBI acts as the National Central Bureau of Interpol in India. Lokpal and Lokayuktas. Following institutional devices have been created in different parts of the world to deal with the redressal of citizens' grievances. First, the ombudsman system. Second, the administrative court system. Third, the procurator system. Scandinavian institution of ombudsman is earliest democratic institution. The institution of ombudsman was first created in Sweden in 1809. The ombud is a Swedish term and refers to a person who acts as a representative or spokesman of another person. The Swedish ombudsman deals with the citizens' grievances in the following manner. First, abuse of administrative discretion. Second, maladministration. Third, administrative corruption. Fourth, nepotism. Fifth, discourtesy. The Swedish ombudsman is appointed by the parliament for a term of 4 years. He can be removed only by the parliament on the grounds of its loss of confidence in him. He submits his annual report to the parliament and hence also known as parliamentary ombudsman. He is independent and constitutional authority and enjoys the powers to supervise compliance of laws and regulation by the public officials. The ombudsman can act either on the basis of complaint received from the citizen or suo motu. He only reports the matter to the higher authorities for taking necessary action. Characteristics of the Swedish institution of ombudsman are as follows. First, independence of action. Second, impartial and objective investigation. Third, suo motu power. Fourth, uninterrupted access to all files of administration. Fifth, based on doctrine of administrative accountability. Sixth, wide publicity in press and other media. Seventh, direct, simple, informal, cheap and speedy method of handling complaints. New Zealand is the first Commonwealth country in the world that adopted the ombudsman system in 1962. The ombudsman in India called Lokpal or Lokayukta. Lokpal, the Administrative Reforms Commission of India, recommended the setting up of Lokpal and Lokayukta. The Lokpal would deal with the complaints against ministers and secretaries at central and state levels, and the Lokayukta will deal with the complaints against the other specified higher officials. The ARC kept the judiciary outside the purview of Lokpal and Lokayukta as in New Zealand. The institution of Lokayukta was established first in Maharashtra in 1971. Lokpal and Lokayukta Act 2013. Features of the Act. First, it seeks to establish the institution of Lokpal at the center, Lokayukta at the state level, and thus seeks to provide a uniform vigilance and anti-corruption roadmap for center and state. The jurisdiction of Lokpal includes Prime Minister, Ministers, Members of Parliament, Group A, Group B, Group C, Group D officers and other officials of the central government. Second, the Lokpal consists of chairman with a maximum of 8 members, of which 50% shall be judicial members. Third, 50% of the members of the Lokpal shall come from amongst SCs, STs, OBCs, minorities and women. Fourth, the selection of the chairperson and the member of the Lokpal shall be through a selection committee consist of Prime Minister, Speaker of Lok Sabha, Leader of Opposition in Lok Sabha, Chief Justice of India or sitting judge of Supreme Court, nominated by Chief Justice of India, and an eminent jurist to be nominated by the President of India on the basis of recommendations of the first 4 members of the selection committee. Fifth, our search committee will assist the selection committee in the process of selection. 50% of the members of the search committee shall also be amongst the SCs, STs, OBCs, minorities and women. Sixth, the Prime Minister has been brought under the purview of Lokpal with the subject matter exclusions and specific process of handling complaints against the Prime Minister. Seventh, Lokpal's jurisdiction will cover all categories of public servants. The Lokpal will have the powers of superintendence and direction over any investigation agency. It incorporates provisions of attachment and confiscation of property of any public servants acquired by the corrupt means. It lays down clear timelines for preliminary inquiry, investigation and trial. And to achieve this, special courts to be set up. Drawbacks or shortcomings of the Lokpal and Lokayukta Act 2013. First, Lokpal can suo motu proceed against any public servant. Second, emphasis on the form of complaint rather than substance. Third, heavy punishment for false and frivolous complaints against public servants may deter complaints being filed to Lokpal. Fourth, anonymous complaints not allowed. Fifth, legal assistance to the public servant against whom complaint is filed. Sixth, limitation period of 7 years to file complaints. Seventh, non-transparent procedure. National Investigation Agency. It was constituted in 2009 under the provisions of National Investigation Agency Act 2008. It is the Central Counter-Terrorism Law Enforcement Agency. It was established in the wake of 2008 Mumbai terror attack, popularly known as 26/11 incident. The headquarters of the NIA is located at New Delhi. The branch offices of NIA are located at Hyderabad, Guwahati, Mumbai, Lucknow, Kochi, Kolkata, Jammu and Raipur. In addition, NIA has separate cell known as TFFC cell dealing with the subjects of fake currency notes and terror funding. NIA is headed by a Director General. He is appointed by the central government. His powers are similar to the powers exercised by a Director General of Police in respect of the police force in a state. National Investigation Agency works under the Ministry of Home Affairs. State government extends all assistance and cooperation to the NIA for investigation. Reasons for creating National Investigation Agency. First, India has been victim of large-scale terrorism. Second, complex interstate and international linkages of such incidents and their connections with the other activities like smuggling of arms and drugs, pushing in and fake currency circulation and infiltration, etc. The functions of the National Investigation Agency. A. To investigate and prosecute offences in respect of the acts specified in the schedule of the National Investigation Agency Act. B. To provide assistance and seek assistance from the other intelligence and investigation agencies of central and state government. C. Take measures for speedy and effective implementation of the provisions of the NIA Act. The jurisdiction of the National Investigation Agency. NIA has concurrent jurisdiction to investigate and prosecute offences affecting sovereignty, security and integrity of India, security of state, friendly relations with the foreign states, and offences under various acts enacted to implement international treaties, agreements, connections, and resolutions of the United Nations organizations and its agencies and other international organizations. NIA is empowered to probe terror attacks including bomb blasts, hijacking aircrafts and ships, attacks on nuclear installations, use of weapons of mass destruction. In 2019, the jurisdiction was extended and NIA is empowered to probe offences relating to human trafficking, counterfeit currency or banknotes, manufacture or sale of prohibited arms, cyber terrorism and explosive substances. National Disaster Management Authority. Government of India had set up a high-powered committee in 1999 and a committee in 2001 after the Gujarat earthquake to make recommendations on the preparation of disaster management. However, after the Indian Ocean tsunami of 2004, Disaster Management Act 2005 was enacted. Act provided National Disaster Management Authority. Initially, the National Disaster Management Authority was constituted in 2005 by an executive order. Subsequently, the National Disaster Management Authority was notified in 2006 under the provisions of the Acts. The National Disaster Management Authority consists of a chairman and other members not exceeding 9 members. The Prime Minister is ex officio chairman of the National Disaster Management Authority. Other members are nominated by the chairperson of the National Disaster Management Authority. The chairperson designates one of the members as vice chairperson of the National Disaster Management Authority. The vice chairperson has the status of a cabinet minister, while other members have status of a minister of state. The National Disaster Management Authority is the apex body for the disaster management. It works under the control of Union Ministry of Home Affairs. Objectives of the National Disaster Management Authority. First, to promote a culture of prevention, preparedness, and resilience at all levels through the knowledge, innovation, and education. Second, to encourage mitigation measures based on the technology, traditional wisdom, and environmental sustainability. Third, to mainstream disaster management into developmental planning process. Fourth, to establish institutional and techno-legal frameworks to create an enabling regulatory environment and a compliance regime. Fifth, to ensure efficient mechanism for identification, assessment, and monitoring of disaster risk. Functions of the NDMA. First, to lay down policies on disaster management. Second, to approve the national plan. Third, to approve plans prepared by the ministries or departments of the Government of India in accordance with the national plan. Fourth, to lay down guidelines to be followed by the state disaster management authorities in drawing up of the state plan. State Disaster Management Authority. Every state should establish a disaster management authority. The State Disaster Management Authority consists of a chairman and other members not exceeding 9 members. Chief Minister is an ex officio chairperson of the State Disaster Management Authority. The chairperson of the State Executive Committee is ex officio member of the State Disaster Management Authority. Other members are nominated by the chairperson of the State Disaster Management Authority. Chairperson designates one of the members as the vice chairperson of the State Disaster Management Authority. Chairperson of the State Executive Committee acts as an ex officio chief executive officer of the State Disaster Management Authority.